This is a tutorial on the residential lease after sale form, CAR form RLAS. This form is used when the seller is going to remain in possession after the close of escrow for at least 30 days or more. Now, if the seller is going to remain in possession for less than 30 days, you'll use a different form. That form is called the seller in possession, or CAR form SIP. And that's just a shorter version of this. This is a little bit more comprehensive because the seller is remaining in possession as a tenant for 30 or more days. So this form is a little bit longer, but we'll go through it and we'll make it real easy. All right, we start up here with the date that we're drafting the form, and then we have the names of the parties. You'll notice that you have buyer, which is going to become the landlord at closing, seller, which becomes the tenant at closing because the seller's staying in possession as a tenant. And you'll put the close of escrow that's scheduled. You'll put the property address, and then it's going to ask you who gets permission to use the premises as their residence. I put the seller because the seller is going to be in possession, but people will add the seller and any other relatives that might be living on the property or significant others, even pets. But basically, whoever's going to occupy the premises, you put right here. Now we come down to the term. I just put 60 calendar days. You can put in a definitive date right here if you want, or just basically calendar days after the close of escrow. Pretty straightforward. Date or number of days after closing. Escrow payments. So I'm a strong advocate of having money withheld in escrow, whether you're doing the SIP form, the SIP, or this, the RLAS. I think that if the seller is going to remain in possession as a tenant, the seller should have the deposit and as much of the rent as possible withheld from their proceeds by escrow and then dispersed to the buyer/landlord. Because basically that buyer, once you become a landlord, you're incurring a lot of liability, and the buyer needs to be protected. The buyer should be in possession of a security deposit and as much rent as possible. So I checked security deposit here, first month's rent. Now it says rent for the entire lease term, but then it has a stipulation, and it says if lease term is at least 6 months. Then there's other. You could write something else in here, but basically as much, in my personal opinion, as much of the amount due for the lease term and the security deposit should be withheld by escrow and dispersed to the buyer/landlord. Now we come down here to rent. How much is the tenant paying? You know, this form actually is kind of flawed because it has a per month payment, and there really should be a per diem option, especially since this is a daily. This is up here. The term is indicated in the format of days as opposed to months, but whatever. It's fine. So we'll just put $5,000 per month, assuming that this is several months. Now this of course could end at some random time, and you would just prorate whatever the monthly is. So let's say up here you put a calendar date and it's 2.5 months. Well, you'd still prorate it. So 2.5 months would be $12,500. So that's the idea. Ultimately, that's what the tenant is going to pay. You're just calculating based on the theoretical full month value here. If I say anything that you have a question about, please leave a comment. I'll be happy to answer. But this is pretty straightforward. You put whatever the monthly amount is, and then you're going to, and by default, it's due on the first of the month. Naturally, if it's paid through escrow, then it's just due the first of the next month or whatever hasn't already been collected. But you can see that a lot of this is boilerplate text. You have to do the very minimum here by checking these boxes, putting a dollar figure amount here, putting the term up here in paragraph 2, and just leaving the rest alone, and you'll be fine. So it looks like a lot, and really the theme of this form is it looks like a lot, but it's not. So payment, I checked the box through escrow because that's what we want. We want the first month and deposit at the lease to go through escrow. Now, of course, if you have a different arrangement, you can use personal check, cashier's check, whatever you want. Rent to be delivered to whom? You'll put that person's name. You'll put the address of where it can be mailed or overnighted if the seller is paying it through the mail or needs some sort of address on record for the landlord slash buyer. You can put that right here. And then this has, I mean, if you want to get more comprehensive, I mean, there's hours, 9 to 5 you could put on the following days, Monday through Friday. But I think you don't even need to put that if you don't want to. It just depends how specific do you want to go. You can really go through this form with a fine tooth comb and tie it down on more stricter terms if you want. But I'm just showing you what, if you want to just burn through this form in a matter of minutes, this is all you need to do. I put a security deposit equal to 1 month of rent. Pretty straightforward. Again, how are you collecting it? I put through escrow. Well, I didn't check the box. So I would check this box here and then transferred to and held by the owner of premises. This is important because escrow can't disperse without permission from the parties. So it's not enough to say escrow withholds this money. And you can write that in. I mean, you can write in anywhere, escrow to hold on to X number of dollars or all the, the entire amount of the deposit plus the lease term. But the problem is escrow can't release it to the buyer slash landlord unless both parties agree. So it's important to check this box transferred to and held by the owner of premises. So you'll want to check through escrow and then down here transferred. Look at all this boilerplate text. You can just leave it all alone. This is standard. It's going to protect the clients. It's straightforward. Unless you have a special arrangement, you don't need to mess with any of this. Have the party's initial, and we're moving on. All right, parking. This is straightforward. I mean, is there parking? Is there a space? Is there additional parking that must be paid? You'll indicate so right here. Storage, is there additional storage? Is there a storage shed or additional detached garage? You'd indicate so here. Utilities, I think it's good to be explicit about utilities because sometimes people get confused on what the term of utilities is. And quite frankly, this form, one way it could have been better is typically in a legal form, you'll have a section of definitions, which the RPA does a good job of, but I don't see, now I could be wrong, but I don't see anywhere in this form where it defines utilities. So that's one small case where I think it's ambiguous. And you could write tenant agrees to pay for utilities and the following charges. If there is landscaping or pool maintenance or whatever else, write it in there. That way there's no dispute about it because utilities often means water and electricity and even trash collection can be debatable. So to dispel any ambiguities, I would write in whatever you could right here in addition to, I would say water and electricity are pretty much given, write in the rest here. If there's any special sorts of arrangements, you'll indicate so here. Condition of premises, pretty straightforward. And, it's important to make note of the condition of the property because the whole point of the buyer slash landlord holding on to a deposit from the seller is because the seller's moving out after escrow. The seller's moving out after the buyer has become the owner. And if the seller punches a hole in the wall, the drywall by accident, moving the headboard, moving out can be messy. That needs to be reflected here. So if you can do a MIMO, move in, move out, MIMO. I don't even know if people call it a MIMO, but I just said it. So the MIMO, move in, move out, then that, and this can be on a Word document, but I would at some, whichever way you can, I would clearly write, or I'd do an inspection or a final walkthrough of what the condition of the property is, so that if any damage is incurred upon the tenant vacating the premises, the buyer can bill that tenant for the damage. Buyer slash landlord can bill the tenant for that damage out of the deposit. Maintenance. And then this addresses landscaping. Straightforward. This is easy checkbox stuff. Pets, smoking, is it allowed? If there's an HOA, some of this stuff, the seller's living there, so they know. They should already know. Seller's going to have the keys. The seller should have all this. Now, here's a really important topic I should bring up that comes up. So often I'll get calls and the buyer slash landlord will be doing a SIP, seller in possession, or RLAS, this form, Basically, the buyers become the landlord, and their agent or even the buyer will say, I never got keys. I have no access. I have no way to access the premises. Am I allowed to? And the seller can be weird and say, you don't get it. We're not comfortable with that. The bottom line is the seller becomes a tenant. They're not an owner. And upon close of escrow, per the RPA, the buyer who becomes the landlord is entitled to get all this. So it would be good for, in a perfect world, the buyer would, the buyer and the seller would get together and they would exchange keys and copies would be made and a certain number would be given to the tenant/seller to retain, and the rest would be in the possession of the buyer/landlord. But everything needs to be written here because, again, if this is missing, if you lose a particular key to a common area like the HOA pool and the HOA says, oh, it's $50 or $100 to have a new key, that needs to come out of the buyer's deposit. So go ahead and write, if there are keys, you need to write it in here, whichever keys pertain to this property, however many remote control devices for the garage. But this is one section that should not be overlooked and should prompt a conversation for the buyer/landlord to collect any and all keys and remotes. Entry, more verbiage here. How about this is, a lot of this verbiage is, what do you do if something goes wrong? Because something comes up that you may have never thought of, and then you have to go back to the form and say, well, what does our lease agreement say? A neighbor calls, I don't like how this person's smoking on the balcony. Who knows? But as a landlord, once you enter the world as a landlord, there's a lot going on, and buyers might think, oh, I'm just letting the seller stay there for 2 months. Well, yes, but you're also a landlord and there are laws and you're responsible. And if anything goes wrong or the seller's psycho ex moves back in and causes problems, whatever happens, you're now the landlord to that. So important to keep that in mind. Obligation, vacating premises, early termination. These are all provisions that come up. And as a broker, this is what I'm looking at. Someone says, hey, early termination, tenant prepaid everything, wants some of it back, and we have to figure out these how to solve these problems. But I'm looking here at all this boilerplate verbiage. So that's the benefit of it. I'm just scrolling through because you don't need to do anything. I'm just saying that this is there for whenever you need it. Notices. Both parties should have an address, phone number, as much information as possible here. Now listen, this form changed. I'm going to scroll up really quick to the top. I'm going to show you that you'll see that June of 2022, so just this summer, this form changed. Now I went to look up what the changes are. It's not much, but I'll show you. It's a very important change. And one other important topic we need to touch on. So again, both parties are going to exchange information here. Now, let's go down to advisories, of course. You'll check, so mold automatically because it's required. Lead-based paint. Check the boxes if it applies. I would say that's something to keep in mind. Check the box if it's applicable. All right. This was added. I'm pretty sure that this was one of the changes of the form, termination of agency relationship. Now, remember how up above I just showed you that both parties should have their information? First off, as a broker, when a transaction closes, both parties, both the buyer and seller, should exchange information. That should happen. And agents are territorial and weird for whatever reason, but that's not legally sound behavior because upon close of escrow, the agency relationship ends. That's it. And agents, I know they've built a relationship and they don't want to give their client the feeling that they've just bailed on them at the end, but there's only so much you can do. And if something goes wrong, that client is going to call the agent and the agent starts trying to negotiate for fees or for their client to be recompensated for something. And at that point, you're effectively acting as an attorney. You're not, you have your real estate license does not give you permission to negotiate a settlement on behalf of someone when there's no open transaction. I mean, this is, at this point you're acting on behalf of attorney in fact, or fake attorney, or whatever term you want to assign someone that is acting on behalf of another party to negotiate legal matters or disputes without the proper authority. That's what's happening. And so, agents need to walk a fine line where they are helpful, but they don't become some sort of pseudo attorney. So this form clearly defines that, hey, just because there's a lease doesn't mean that I'm going to be here the whole time, I as your agent, going back and forth about everything that comes up. You're not the property manager. Your job is done once either escrow closes or the lease is consummated, whichever comes first, and they're going to happen almost simultaneously. And so the point of this, and something I'm advising you in general, is to, take heed of this, that the agency relationship ends at close of escrow or upon entering into this agreement. And that's it. It's not your job to take the call from the tenant or the landlord and to be their representative and to have them delegate what they should be discussing between them. That's it. The parties need to be introduced to each other and realize that, hey, you guys have engaged in a contractual relationship. Escrow closed. You're no longer buyer and seller. Now you're tenant and landlord. Figure it out like adults. All right. Foreign language translation. Okay, just more boilerplate. Representative capacity. If one of the parties is a trust or something like that, they have an area for if there's a translator or interpreter involved. That's it. We've really gone through it. And I've gone into depth with my explanations, but if you see through, there was very little that we checked or wrote in. You'll fill this out, pretty straightforward. Tenants, landlords signing, real estate brokers signing. That's it. We're done. Now there's a bedbug disclosure. Why? It's required by California state law. Pretty straightforward. Kind of silly, but whatever. We sign it. The party's been advised. We've fulfilled our obligation. Same thing with tenant flood hazard disclosure. Again, required by California state law. It comes automatically, populates with the form. We do it. Here's another one. Rent cap, the rent cap and just cause addendum. This is this. I don't even know if this is required by state law, but basically it's good to make sure that, this automatically populates with the form, but California has state mandated and rent control elements in place in addition to local rent control or local rent ordinances that actually are supplement state rental ordinances. So I would say no matter what, keep this form in there. It's good to let people know of I would say yes, that this form is obligatory to keep with an RLAS, and then you have mold. So advisory, and we're done. Okay, if you have any questions, please leave a comment. I do hope you found this helpful. Thank you.